Hello, good morning. My name is Helen Tarokic. I'm a North Carolina board certified immigration law specialist. I'm here to do my best to answer some general immigration questions, provide some information that hopefully will help people get inspired to move forward with their immigration cases or re-strategize if needed. Our law office is Helen Tarokic Law, PLLC, based in Wilmington, North Carolina. I'm a licensed attorney. Our office is based in North Carolina, but we do handle immigration matters throughout the U.S. as it pertains to federal immigration law. And today you can put your questions in the chat if you'd like to. We're on Facebook Live, and this is also on YouTube Live, so you can post your questions in the chat either way. And if you are watching today, you'd like to ask your question in Spanish or in Croatian, I will do my best to answer that way, and then I will try to get it back into English for those who are listening. So for today's topics, our session is about, do you have questions about immigration and just don't know where to start? So we're going to look at questions that really do affect what most families are facing today. Our topics today for questions can include immigration options for families, green cards, citizenship, work permits, renewals of work permits, receipt notice issues, deportation concerns, immigration court questions, humanitarian options, business immigration, student issues, just general immigration guidance. And as always, I just want to remind people that, of course, the presentation today is a presentation that is designed for immigration, general information, and education. So this presentation does not create an attorney-client relationship. Please, if you're asking questions, try not to give such specific information that it could risk your personal situation. Of course, we're going to try to give general questions and answers. And during the broadcast, you can support our law firm Facebook page by sending stars if you're on Facebook. That is a digital gift that helps us improve our program. Even if it's like just a few stars, that's great. It helps us broaden our reach. It makes a huge difference in terms of how far our program is shown, who it can reach, that sort of a thing. So if the information we provide today is helpful to you, you want to support our immigration programming, you can send stars on Facebook. If you're on YouTube, there's no star sending, but on YouTube, you can like, you can subscribe, you can share as well. And just know that we have lots of videos and webinars on our website at tarokic.com/videos. And you can also subscribe and follow us on our channel at Helen Tarokic Law for YouTube. And that has English, it has also Spanish, and also Hindi, Urdu. So you can watch us in 3 different languages. And for the Hindi one, of course, it's in English and Hindi, Urdu, because, of course, I don't speak those 2 languages. But I do speak Spanish, and I do speak Croatian. So again, my name is Helen Tarokic, and I'm here to answer questions. I think I'm getting started a little bit late today, too. So if those of you were waiting, I really do apologize. I was in a really important meeting. So I am a person who's not just doing videos. I'm an attorney who has like a full caseload, and I manage our law firm. And of course, always trying to make sure that we get everybody the information that we need. So thank you so much for joining us today. I can talk to you a little bit about some of the things that we've been seeing as we have reviewed cases. So sometimes people will come to us for just a second opinion to take a look at what they have filed and what is pending. And so I'm just going to talk about 4 things that we're looking for if we review a T visa case filed by another person or another law office. So one of the first things I'm looking for is in the application copy that the client has for their second opinion consultation. is there a signed victim statement? So we really have seen some issues with people filing T visa applications that don't have a properly signed victim statement, and that really is a core item. It's one of the 4 core items that you need to have for a T visa filing. Another thing that we're looking for is we want to see if the application forms have been fully signed and are they fully completed. So sometimes we'll see like um, a signature is missing or a person signed in the wrong place. So those signatures are things we're looking for. Another thing that we're looking for is, was the trafficking actually reported in some way to the Department of Labor or another law enforcement agencies? So there's been some scams out there. The ones that I have seen have actually been filed by non-lawyers. So these are notarios or form preparers or consultants. They're not real lawyers. But they're filing some kind of a victim statement with the T visa case, but they haven't reported anything to law enforcement. And so that's a big deal. And I can see why they're not doing it, because if they don't report to law enforcement, there's less chance that that notario or scammer is going to get caught in their scam, because it takes a lot to report to the FBI or Department of Labor. And if you're doing something unlawful and then you report to them, more chances of getting caught. So if you have filed an immigration case with a notario or non-lawyer, and you don't see that the trafficking has been reported, that's a big red flag, and that's something that we look for in the cases that we review. If you're stuck in a pickle and somebody has filed your T visa case and they're not an attorney, we are interested in helping in those cases. So sometimes there's an amendment, or we can enter an RG28, take over the case, try to fix it while it's pending. However, sometimes we actually have to work on a withdrawal of an application and it cannot be amended, and we need to refile a whole case. So we are interested in helping people in those situations, and our consultations are confidential, related to everything that went on to get the case filed. So oh, this is such a sweet comment. So somebody said they had a consultation with me and loved it. That people might look at the price for a consultation, think it's expensive, but for the quality of the call and everything you do, it's nothing. So thank you so much. I'm so glad that I made a good impression. I did a good job there. That makes me so happy. #1 fan in Florida. Thank you so much. I love this. I really appreciate it. Thank you so much for being on today. So sweet. Yeah, so we definitely in our consultations spend a lot of time looking at the file, seeing if there's anything that we can improve, and always trying to help people, give them, if it's a second opinion or it's just the first time they're doing something, really give them like a path and a strategy. And that does take time. And that's, one of the reasons why our consultation fee is significant. But my goal is that when we're done with the consultation or shortly after, we have a game plan for people. And on that note, sometimes I look at cases that have been filed by other law firms, and they're really good. There's always different strategies that people take to file an application and ways that they're prepared. And I really love it when I see a case that's been really well done. And, if there's anything I can offer, they're usually sort of little things that could help down the road, long-term stuff that are, sort of bigger considerations, that kind of a thing. But I also do see, good cases come across my desk as well. So it's always nice to know, how hard people are trying to do things, right, and get really good cases filed. So if anybody has any questions, I'm happy to answer them. You can put your questions in the chat and I'll do my best. I think I was just talking about some of the bigger issues that we see. So sometimes the victim statement isn't signed. Sometimes the forms are not properly signed. Sometimes there wasn't a report to law enforcement at all, and it didn't fit into one of the exceptions where people can avoid reporting in order to file the T visa. So there is a trauma exception and some other narrow exceptions for not reporting trafficking prior to filing. Very rare situations. So most of the cases I see that really have a problem are ones that don't fit the exception there. And then finally, one of the things that I am looking for with T visa filings is the criminal history disclosure. So those are really tough things sometimes for, especially if it's like a notario or a non-lawyer has filed an application, they almost always do not list immigration inadmissibility or criminal history correctly. Sometimes it's totally missing. Sometimes it's incorrectly described, and that can be a big issue because if you want to get a bona fide determination on your pending T visa case, you also want to make sure that immigration has what they need to be able to issue one. And the biggest thing is if you have failed to disclose certain criminal history or you have a major criminal history hasn't been addressed properly, then most likely that bona fide determination for the T visa case can't be issued. Now, oftentimes, again, when we're talking about cases that real lawyers file, very different. There might be like a traffic infraction or something small that there's some confusion or something got left out or they couldn't find like a DMV record or something like that. Those can be hard to get. So sometimes there's like little things, but more often what I'm seeing with non-lawyer notarios is the problem that they're not providing the history correctly at all. They just file whatever. I've seen it where they don't even put the applicant's name down correctly. Sloppy birth certificate translations that only translate half of the document, stuff like that. So yeah. Another thing that's come up in questions lately for people has been more just connected to the class action lawsuit and the protective order that came out back in May. So now it's been about 2 months since the court said ICE cannot be blind to people having victim cases pending, that they have to treat victims with some level of respect and consideration, knowing that their applications typically are ones that need to be completed while they're inside of the United States. So the ICE cannot be blind thing has gone pretty well. We've had a lot of reports of ICE treating people more respectfully, declining to detain individuals who have pending victim cases, which is great. And just also attorneys reporting back to me in some of our classes and stuff, just sharing that they had situations where a client was detained, but using references to the class action basically restraining order that says immigration officials like ICE do have to provide certain protections to victims, that worked to ultimately get their clients released. So I know there's lots of stuff in the news. The government doesn't always do its job right, but I've definitely seen a huge shift now with that court order protection where ICE has been walking back some of the mistreatment that formed the basis of that lawsuit. So really great things there. Okay, so we have a comment. Thank you so much. So there was, a situation where the person didn't find out about biometrics. It sounds like the lawyer took a month to let them know about the biometrics, so they were late to the appointment. Then waited 5 months to call USCIS. They said the case was abandoned. And then because it was a T case, they would give her one opportunity to submit biometrics, or would they do that maybe? So this is interesting. So if the case had not yet been denied and a person missed biometrics, typically, as long as you can get the biometrics rescheduled or taken before final decision is made on the T visa application, then the T visa case is actually not abandoned. If you get a denial notice saying you missed biometrics, it's denied. Sometimes, especially if you can establish that it wasn't the client's intention to abandon the case, that there was some type of issue with the mail or communications. USCIS has been doing some pretty crazy stuff too, like dating a biometrics letter with one date, but not mailing it for a couple weeks. In those situations, sometimes there is the possibility to do a motion to reopen to restart that case. And in other situations, yes, it does need to be refiled. Now, sometimes there are reasons to really try to save the old case. Like, for example, if there are derivatives who are going to age out, like somebody is turning a specific age that will make them, like maybe it's somebody who needed to file a T3 case prior. to the 21st birthday, and the T1 case was filed prior to the 21st birthday, but now the kid has turned 22, and now we've got this other issue related to abandonment of the T visa application. That might be a reason to really work on trying to salvage the original T visa case. But biometrics and communication with law offices is definitely key. In our office, we've definitely had some biometrics notices come super late to our office, like 24-hour notice kinds of emergency situations. Has been very frustrating with the mail. And then we've also seen it where, we get the notice on time, but we're calling, texting, mailing, emailing the notification to our clients to try to make sure that they attend the appointments. And then something will happen. Sometimes clients just mix up the date, get confused, get sick, can't get a ride, something happens. So we have to work with rescheduling. I usually don't actually call USCIS over this issue. So one of the things in the sort of hypothetical here was, the person waited a long time to call immigration. Normally, we will email the USCIS hotline for victim cases. So there's an email address for attorneys to email. Takes a lot to send an email. We've got to attach our G28 notice of attorney representation. We have to provide receipt attachments, receipt numbers, specifically name out our client's details and also our details, even if it seems like it's obvious because it's already on the information we're attaching, and then get a correct subject line related to biometrics rescheduling, and then make a proper request, and then wait to hear back. Sometimes we do call as a follow-up, but usually I try to get this in writing because saying you called, there's not really documentation of that. So like if something later happens, I definitely want to have a written record. So that hotline to USCIS where we can email in inquiries is very important. But sometimes, people say call or contact, and what they really meant was email. And so, it may be that email hotline was used, or that there were follow-up calls, not to know what happened in that specific case. But I did just want to mention, if somebody has an issue, that oftentimes with the pending T visa case, emailing, or with U visas, emailing that same hotline email can really help out in certain situations. So, yeah. Okay, so then we have another question. So someone applied for a T visa case, has already done their biometrics. And also thank you for the shout out. I appreciate that. Adriana, hello. Thanks for being on today. It's so great to see you here. And Pooja, thanks so much for dropping in. So it sounds like you've got a T visa case pending, biometrics are done, haven't applied for the BFD work permit yet. So the attorney said it's a long process. USCIS is denying more of those days. So there's some confusion there. And so the fear is if you submit a BFD work permit, the C40 I-765 application, and then USCIS decides they don't want to grant the work permit, what would happen? Would they then put you into deportation or something like that? Okay, I am going to break this down, and I think that there are two schools of thought, and I think that either one is an acceptable standard of how to do things right now. In a month, in 6 months, things could change, but I definitely know some really good lawyers who are saying, let's hold off on the work permit application, because if they deny the bona fide determination work permit, we're concerned that they might issue a notice to appear for removal proceedings, not because you have a pending T visa case, but because you've received a work permit denial related to the BFD. I understand why people would do that. I am doing it differently. My opinion may change over time. A lot of what we do is based on what we're seeing in our office. And then, of course, our strategy theory of the case. So one of the things that I see is that if a bona fide determination is going to be negative, saying that they don't think that the case is bona fide, then right there you already have some, let's say, negative action taken on a pending case. Whether or not a person has the plastic work permit application pending, if USCIS says the case is not bona fide, you may run a same or similar risk of a notice to appear for removal proceedings, right? So if they're saying the case isn't bona fide, they could issue unfairly a notice to appear for removal proceedings. And if they're saying the case isn't bona fide and they're also denying the work permit, same thing. They could issue a notice to appear for removal proceedings unfairly. Is there any more risk at that point? I think it's very hard to judge because we have already submitted FOIA requests, a Freedom of Information Act request, to try to get that bona fide determination adjudication checklist from immigration. I want to know how they're making their decisions. And is there some kind of worksheet for, are we going to put someone into removal? And I want to see what that is. I want to know what process they're using, because right now we're kind of stuck in this. They've never done this before. They certainly didn't do it under Biden. And so why is this now happening under the current administration? So we have some things that are unanswered because I don't have those documents from immigration to really say. And so I think that lawyers are really in between a rock and a hard place, and so are their clients. So there's a regulation, okay? There's a regulation, and actually, this will be fun. My new book came out, The TV's the Framework. I have it all Post-it noted because I'm always looking for more typos in a book I just published or something else that I want to change later on. Anyway, I published this book to try to give lawyers sort of an overview of T visa cases, some great ideas for screening, just some strategies and things like that that lawyers can work on. And one of the things that I'm addressing in the book is like, why should you file a T visa case? And also, some of the risks that people might face, like this, scare that people have related to bona fide determinations or, being placed into removal. And so I'm going to talk a little bit about the T visa regulation that came out in 2024. I'm going to pull it up here. I think I probably have it memorized at this point. But basically, the regulation says that USCIS generally will not place somebody into removal proceedings, even like while they have a T visa pending, or if a T visa case is denied, unless the person has an egregious criminal history or they're a terrorist or a trafficker. So if you're not a terrorist or a trafficker and don't have a egregious, super serious criminal history, then denying a bona fide determination work permit should not result in a referral to removal proceedings. So here it is. Referral, this is straight from the regulation. Reading from my book where I quote the USCIS regulation. Referral of applicants for removal proceedings. USCIS generally will not refer an applicant for T non-immigrant status for removal proceedings while the application is pending or following the denial of the application, absent, so like unless there are serious aggravating circumstances such as the existence of an egregious criminal history, a threat to national security, like being a terrorist, or where the applicant is complicit in committing an act of trafficking. So unless it's an egregious criminal history, you're a terrorist, or I suppose a spy would also be a threat to national security, or where the applicant is complicit as like an actual trafficker themselves, you shouldn't have a bona fide determination denial resulting in a notice to appear for removal proceedings. But all this to say, and I know I talk a lot and always have long answers, but all this to say, just because under the Biden administration, there was never this notice to appear for removal over a denied T visa case, nor over a denied bona fide determination, because we used to get some under Biden as well. Just because that didn't happen under Biden, and now we're in this new situation where it shouldn't happen under the new regulation that came out in 2024, and now we're in 2026, it doesn't mean that something bad won't happen, right? So we've seen in the news, ICE has arrested American citizens and even deported some of them erroneously, right? And so there were lawsuits about them doing wrong things. And we have seen a case where a person didn't have any significant criminal history, like really no history to speak of other than some traffic tickets. And yet, when immigration decided that case wasn't bona fide, they they went through full T visa decision. They decided to send a notice putting that person into removal proceedings. So why would they do that if generally they won't do it if the person doesn't have this serious criminal history? I don't know. I think they made a mistake. So in that case, fortunately, there was really good representation. Removal Defense Counsel communicated with ICE, the attorneys for ICE, and with the immigration judge before there was ever going to be like a trial in immigration court. Our office filed an appeal and a lawsuit as well against immigration, made it very clear that this never should have happened. And then ultimately, the immigration judge and opposing counsel agreed to jointly terminate deportation proceedings for that client. And then we won our appeal. So there are things like that that can happen which are not fair. There's certainly risks to filing a T visa case. But I did just want people to understand that if the government's going to do something unlawful, you just want to be prepared to deal with what they've done that is inappropriate or incorrect or erroneous. And right now, I'm not at the stage where I think that not filing a C-40 EAD is the way to go. However, I might change my mind in a few weeks. I don't know. We're looking right now at situations where we really haven't seen in our office this pattern of issuing notices to appear to people who don't fit the criteria to be put into removal proceedings. That said, I have had some bona fide determination denials recently, which I'm not happy about. We've had some really good ones come through recently that we're super excited about, and we had some that came back as negative, and all of those cases were good cases. There's no reason to get a negative bona fide determination in those. For the most part, the ones that we're dealing with, though, are also ones where we've been doing some litigation, like a mandamus action to try to force immigration to move forward more quickly with decisions. And so now our steps are, look, if you're going to do a negative bona fide determination, are we going to go back to having to sue to get a full T visa decision then, right? So a negative bona fide determination doesn't mean you're not going to win your case. It means that immigration hasn't issued a document that we want. And so now we want to push for full T visa approval, hopefully. And if that case isn't approved, if it's a case that we prepared, we believe in, we're going to want to do an appeal or even another lawsuit to try to win the case later. So I know this all sounds like a lot, and it can certainly be really overwhelming. And I don't want to step on another attorney's toes related to that kind of analysis. It's absolutely true that the T visa application process is a very long process. And I understand why some might say, let's not file for the work permit now. For our clients who get bona fide determinations positively in the approved work permits, it is life-changing. It's a huge benefit to get that. But we're also weighing the risk of, well, what happens if it's not a positive bona fide determination? So those are each very individual conversations that I think people need to have. And it is also possible that there is something in the immigration file, I wouldn't know what, that made the attorney go, in this one, we don't want to risk it. We're just not going to agree to file that one right now, and that recommendation may stand. So just know that I'm talking generally about how we're handling things, but there are also some, sometimes there's a reason for not pushing forward with it. So there might be records missing. There might be some other things that you're trying to still get through FOIA. There might be an amendment that needs to happen to the application, or maybe somebody does have something that's related to a criminal or fraud issue that is significant, or just some other experiences that the attorney is having that maybe we haven't had yet, right? So we're not a giant law office. The number of cases that we handle is significant, but others may be having different experiences and have, different opinions. So, of course, if anybody would like to have a consultation with us, we can certainly review a case. Again, my goal is to try to look at the case from an adjudicator's perspective as best I can, knowing I've never been a USCIS adjudicator. I've always been, as an attorney, a private representative. So I don't have like secret inside information about what immigration is going to want in these cases. Instead, it's more like my experience and reading of the law. So if somebody wants a consultation, we can do those. The number is 910-509-7145. I'm always interested in giving the best opinion that I can. Um, and as always, if there's something that someone hasn't told an attorney, but they now want to tell us, we will go over that as well, because we do review the file. We have people fill out a questionnaire. They're going to talk to our screen team to go over the information and make sure that by the time we get to the attorney call, we've got lots of accurate information for us to discuss. Then I'm going to have my own questions. And of course, there's 5 other attorneys at our firm as well, so they do similar reviews. They're going to have their own questions. Each one of them does consultations. So they may have questions that are different than my questions, but they're often very similar in terms of the markers that we're looking for to see if a case is viable. And also, I think that there's a lot of fear in the system right now because it's in the news. They're saying all asylum cases are fake and asylum lawyers are terrible, and TV visa cases are fake and TV visa lawyers are terrible, and these marriages are fake and we're going to catch you at immigration. It's like there's a threat for every type of visa out there right now. And I do think that some of the stuff that's coming out in the news is like trying to pit clients against their attorneys or vice versa. Some concerns are certainly legitimate that people should have and just, want to have some comfort about getting another look. Just like if you had an illness, you might want to go to more than one doctor to get 2 opinions about what the correct course of treatment is, right? But I just don't think we should be controlled by fear. I think we want to look at the facts, look at what's out there, and try to make good decisions going forward. Okay, so then another question, do I need a proof of application for a T visa? For that question, I'm sorry, I'm just not sure what you mean. Like, is it related to a consultation or something else? So if you don't mind just clarifying your question, Steve, I'll do my best to answer. Okay, and then we have a question in Spanish, so I'm going to do this one in Spanish, and then I'm going to get it back into English. So, buenos días, mi abogado envió la visa T en julio 294 con firma electrónica. ¿Hay alguna forma de arreglar eso? Okay, so the question is, my lawyer sent the T visa in July 2024, so about 2 years ago. Is there any way to fix this? And the reason they want to fix it is because the forms had an electronic signature on them in some way. So overall, about 2 years ago, maybe 3, there started to be some issues with electronic signatures. So COVID had happened. Immigration basically was like, you can have electronic signatures on certain things or scanned signatures. And then the interpretation of what that needed to be changed. So immigration was accepting things, and then a year or 2 later was suddenly like, I don't want to accept it. And so some lawsuits came out, and those lawsuits were successful, and now immigration has walked back that issue, essentially for the most part, giving people a chance to fix or cure the electronic signature and submit new signatures in most situations. So I do think that there's a way to fix it, but it's one of those ones of what do the signatures look like and how does the rest of the case look? So I'm going to get that into Spanish. Hace unos años hubo la pandemia de corona y durante la pandemia el gobierno anunció que se puede aceptar un scan de la firma en diferentes versiones, ¿no es cierto? Y diferentes abogados lo interpretó diferente. Entonces, algunos hicieron que las firmas sean de una forma electrónica o usaron una scan de la misma firma, le pusieron en cada página electrónicamente, que sería como una firma verdadera, pero fue la misma firma en cada página del documento en la declaración de víctima. Y hubo litigios sobre eso. El gobierno de repente empezó a considerar estas firmas como insuficientes, pero esperaron 1 año, 2 años o más para decir que no les gustaba la firma. Entonces, de lo que tengo entendido, hubo litigio sobre eso y el gobierno les dio la oportunidad corregir o arreglar eso. Así que hay casos que han sido denegados por la firma incorrecta y de ahí fueron abiertos nuevamente, lo abrieron y de ahí los casos podrían ser aprobados. Pero lo que pasa es que no fueron los casos como míos. Yo tuve una situación donde el gobierno acusó al cliente de no tener la firma correcta, pero fue incorrecto, entonces lo apelamos, lo ganamos, esa apelación. Pero no tuve esa situación de cómo usar la misma firma en diferentes páginas para poder decir, ok, así va a ser en litigio. Lo que tengo más que nada es información que afortunadamente he recibido de diferentes asociaciones que tenemos y también no he visto tantos pedidos para información sobre las firmas ya, así que pienso que esto fue como algo que intentaron de hacer para en una forma causar problemas que ya se arregló. Si quisiera que su abogado mete un nuevo caso, también eso es otra posibilidad, que haga los formularios nuevamente, que recicla mucho la información vieja, que quizás añade información de terapia, otros datos para poner el caso al día y meter otro caso para que tenga dos casos diferentes, pero parecidos pendientes, pero que no sean idénticos. No queremos casos idénticos pendientes. The other thing is just these were not my cases that were litigated related to the electronic signature issue. I'm fortunate to be able to teach T-Visa classes and to also hear from attorneys what their other experiences are, that sort of a thing. And so also having a chance to work with litigators on different issues. We're always glad to hear some good news that it sounds like the electronic signature for the most part has been walked back. And while I would certainly not file a case with an electronic signature, in 2026, I understand that lawyers who did that previously were overall able to cure those cases. But if somebody's worried about it, I think they still do have an opportunity to potentially prepare and file a new T-Visa case. Either case could potentially be approved, right? So that may be an opportunity there. But we don't want to file identical applications. An identical application, you may end up with just one being denied as identical. So what can you do if you're trying to do a brand new T-Visa filing? You might want to update the victim statement with a fresh signature, of course, fresh forms with signatures. Get some updated, proof of therapy attendance or like anything else that just might help in terms of making the case different and better than the first one in some ways, but also just knowing that the first one could still go through. You might receive like a request for evidence related to the signature issue as well. And in terms of processing times, the processing times have changed again. They just updated the processing times saying that they are taking 32 months from the time of filing to be decided. So what does that mean? If you file a T-Visa case, they're looking at data over the last 6 months, really. So over the past 6 months, about 80% of the T-Visa cases that are being filed are decided within 32 months. That's the current data they're sharing, meaning that there's no promise or guarantee that a case you file today is going to take 32 months. It could be shorter, it could be longer. In terms of bona fide determinations, we're receiving those somewhere around the 16-month mark, but I also have cases that have dragged on much longer. Looks like we have some litigation that's settling at the 25-month mark, which is still better than 32 months. So we're working hard to keep USCIS accountable. Así que sobre el tiempo de procesar, también quería comentar que en muchos casos recibimos la determinación de buena fe dentro de unos 16 meses de aplicar, pero en otros casos no. Hemos hecho demandas de agilización que se llaman mandamus. Recientemente el gobierno se puso de acuerdo en un poco de litigio diciendo que iban a tomar ciertas decisiones dentro de 25 meses en vez de estos 31, 32 meses. Y también, como siempre, los tiempos de trámite siguen cambiando. So, yeah, these are great questions. Does anybody else have a question or a hypothetical? I would certainly love to answer if I can or give some general information. Just for kicks, I want to talk a little bit today in Croatian. So, zovem se Helen Tarokic. Ja sam advokat, privatni advokat za migraciju. Znači, ne radim za državu, nego radim za sebe. I naš ured je u Wilmington, North Carolina. Ne govorim hrvatski 100% točno, ali za neke stvari možemo razumjeti se dobro. Ako imate koje pitanje, možete to staviti na chat. Ja ću odgovoriti koliko dobro mogu. Naša konzultacija za imigracije može biti za žrtve vize, može biti za zelene karte, državljanstvo i te stvari. Ako mogu pomoći, bi volile. I ponovo pozdrav. Hvala što ste nas čuli danas. So just a little thank you there and introduction as well. I think most of my Spanish-speaking clients haven't heard me drop in Croatian anytime recently, so I hope that was fun for you. I'm trying to think what else has been new lately. What have we been seeing coming in the door? Some of it has been DACA renewals, so this was crazy. Certainly have clients with DACA renewals pending for 7 or 8 months for no reason. There's like this kind of stuck backlog situation. And so then, of course, we're having our clients file DACA very new. Some people at the 1 year before their work permit is expiring. And then we've had some suddenly approved in a month or two, while others are still lagging. It is very unfair. Sometimes we've been using congressional liaison, meaning contacting a senator's office to request the expedite. That has cleared out some cases. Other times it didn't push the case forward like we had hoped for, and the case is still pending. We've worked on some medical expedites for those cases as well. Those can be called in, or you can do that through congressional liaison as well. The DACA program for renewals is still alive and well. We're seeing cases, for example, even where we don't have a bona fide determination on a T visa case, where the DACA renewal can still go through and be approved. So we definitely have DACA clients pursuing U visas, T visas, marriage cases, or other types of immigration options, but they're maintaining their DACA renewals consistently until we kind of get to higher ground and get them into a better immigration category. So I hope that helps. Let's see, if nobody has any other questions, then I guess I will do a question from my book. Since it's brand new and just came out, which, by the way, you can find it on Amazon. It's called the T Visa Framework. If you're an attorney especially, I think this will be the most helpful for you. It's designed for newer practitioners or people who are newer to T visas, or for people who have a lot of immigration experience and doing T visas but want to get like an update on the law, regulations, and our thought process on that. Oh, okay. Actually, I won't go into the book because I do have another question up here. So is it safe to go to a biometric appointment? That's a great question. So I think overall, our experience has been that, yes, it is safe to go to your USCIS application support center, fingerprint, or biometrics appointment if you have like a pending case. This is not legal advice for everybody. This is not case-specific advice, but if the question is just generally, is it safe to go for a biometrics appointment? My experience has been overwhelmingly positive. So I'm just going to knock on wood. I have never had a situation where one of our clients was arrested at a biometrics fingerprint appointment for any type of pending immigration application. But that doesn't mean it hasn't happened. Again, sometimes immigration has done some really, I would say, inappropriate things. If you're pursuing an immigration case and somebody's trying to arrest at biometrics, that is going to prevent the person, or at least delay or stall them out from pursuing that immigration application. And that's just not fair. There was a class action lawsuit in the Northeast of the United States back when Boston was arresting people who were pursuing I-212 waivers. Those were people who had a marriage case going and they had a deportation situation that needed to be forgiven. And they were arresting people so they couldn't finish out their process. It wasn't at fingerprints, but it was like a similar situation. And the court ruled they can't do that. There's a regulatory legal process that had been created. These people, that's not the time and place to arrest folks while they're in the middle of pursuing their immigration process. Similarly, with pending T visa or U visa applications or other types of immigration cases, it should be safe to go to your biometrics appointment. Now, there have been some verified reports of people who were arrested at their biometrics, and we don't know if ICE made a mistake, if USCIS made a mistake, if there was inappropriate information sharing where people made a bad judgment call to try to do something like that to people who are pursuing immigration cases. But all of the arrests that I heard about, which was very few, were prior to May 20th, meaning it was an extremely rare situation, and it happened before the court ordered ICE to stop being blind to victims. So I think that's very important. I think we are now in a much better position because of the class action lawsuit that had this injunction or helpful order saying that immigration cannot just revoke deferred action without any due process for victims with pending cases, and that they cannot be blind to people with pending victim cases. So I can never promise or guarantee a perfect situation as somebody pursues their immigration matter. And of course, today is July 23rd, 2026. Tomorrow or in 6 months, it could be a different situation. We may have experiences come through the door that are different. But overall, we've had very positive experiences with biometrics, even for people with deportation orders or the permanent bar or who have used other names or identities. Overall, immigration is well aware that those things can be waived or forgiven as part of the T visa or U visa process, and that biometrics is a point to help process an application so that a waiver can be decided. Biometrics is not supposed to be a got you moment. So I hope that helps. Another great question. Thank you so much. This one is, does the T visa applicant get some type of deportation protection after applying with USCIS? That is such a great question. So it comes in different levels. For lawyers who are on listening, you can check out our chapter on deportation in our book. But I'm just going to walk this through from the client perspective and how I how I try to explain it just generally without being overly technical. So when you first start a T visa process and you have not even filed your application, if you were to encounter immigration and they were trying to make an arrest, it is still possible to say, I am a victim of trafficking. I'm in the beginning of my process, and hope that they take into account victim protections that have been in existence for many years prior to this administration and which are supposed to be in place now while that court ruling in the class action lawsuit is in place. Once you have filed a T visa application, again, generally USCIS will not put you into removal proceedings with a pending T visa case or even with a denial unless there is an egregious criminal history, you're a terrorist or a trafficker, right? And then on top of that, the other deportation protection would be when you do get a bona fide determination. That letter specifically says, not to quote it exactly, but that letter specifies that if you have exclusion, deportation, or removal proceedings against you, that those are stayed or stopped while the T visa application is pending with USCIS, which is fantastic, right? We want that bona fide determination protection for our T visa clients. So then what happens if you get a bona fide determination? If you've also filed for a work permit, hopefully they will approve that work permit for 4 years. give you the protection of work authorization, social security number, typically driver's licenses, to cover you through to the final decision in the T visa application, right? And then for people who get a bona fide determination letter, where it's going to essentially stop any deportation process, even if one was never started, it's supposed to stop it, right? While the case is pending. If you haven't filed for work authorization yet, at that point, then you could file. But between the time you get a bona fide determination and then, like, if you've chosen to later file a work permit, remember that immigration is going to make a separate decision as to deferred action and work authorization at a later date and time, so they can use new information or policies or politics to make different decisions down the road. But if you filed concurrently for the work authorization with the T visa application, then when a bona fide determination is granted, then usually that work permit comes within the same week or 2 or 3. It's kind of handled together, as opposed to two very separate decisions. And then in terms of the T visa approval, once T visa status is approved, if you're in removal proceedings, it's actually mandatory for the government to terminate removal proceedings. So if you get an approved T visa and you're in removal proceedings, termination is mandatory according to the statute. So that was another thing I did talk about a little bit in my book. But if somebody has a deportation order already in place, like an in absentia deportation order against you because you didn't show up to court for whatever reason before, and then the T visa is approved, it's not necessarily mandatory to reopen the deportation. It's mandatory to terminate it if proceedings get reopened. So our office has to do some work and file motions and try to get the case reopened and terminated for people who have, like, these old prior deportation orders on their record. And we've gotten some really great wins recently. So even for people who were physically deported and re-entered, and then we filed a T visa years later and got their T visa approval, we've seen that the government has been willing to reopen and terminate those proceedings for some of our clients. So if you can't clean up the deportation order for whatever reason while the person has T status, in terms of, again, what kind of protection do we have, you can have T status even with a removal order against you. And then the next step is later on applying for a green card. And the green card can still be approved with a deportation order against you. And once that's done, then again, you have another shot at, like, reopening and terminating the deportation to clean it up down the road for American citizenship and for making travel easier and things like that. So there's lots of different protections along the way for people pursuing T visas. And it's not always black and white. I obviously get very upset if we don't get a bona fide determination decision quickly, or a positive one. For those, we have to, there's this, it can take weeks. We work through what we can do to try to figure out, is there anything that we could do differently to try to get a positive determination here? Do they have anything under another type of status, like DACA or something else, that we can just renew while we're working on trying to get full T approval? Is there a litigation option? But on the whole, just kind of globally, I'm still seeing pretty good decisions coming out of immigration. So if I have sounded this entire hour like all I did was complain about the government, I do apologize. I often see really great things happening. If I didn't, I wouldn't be filing immigration cases, right? But when we're talking about the what ifs, the things that people are the most scared about, then of course I'm going to talk about, well, if this doesn't work out, here's what we might do. If you don't have protection here, we might go to this other option. We want to always do some good strategy there too. So depending on which service center an application is filed at, it can change processing times, but many times T visa or U visa processing times are all circling. It's like by the time you get to the drop-down menus on the immigration website, they're giving information that's pretty specific there. So overall, though, the 32-month processing time for T visa applications is nationwide. So if your application was filed at one center versus another, probably no major difference there. So just my best guess. But yeah, so that's that. This hour flew by, and I loved all the questions. To each of you who asked a question, you are super brave for coming out and asking today. I know that it's hard to ask questions. It's hard to hear the answers sometimes too, but we will, we'll post our Facebook Live so that people can access it later on YouTube as well. And I hope that a lot of other people will learn from it. Again, opinions vary. And most of the time, I see really great work coming out of lots of different law offices. So if you've asked me questions today that maybe my answers were a little bit different than your own attorney, just try to remember that the attorney relationship with clients is something very special, and communication is very important. If you felt you could ask me a question today that you couldn't ask your attorney, consider what is the issue there. Is it something like maybe you need to contact them for a consultation? Sometimes it's a paid consultation. Is it an email that you need to send? What is there that's making you feel like maybe some more communication is needed? Um, Sometimes the trust relationship is just broken down, and I understand that too. So there may be times when people can't communicate with their counsel, but the conversation is important. That this is all general stuff today, and what's in your actual file is so important. And most of the time, attorneys have worked their hardest and put like all their heart and soul into the application, stuff you can't even see. They've worked just so hard on to get it right and get it out the door. They're out there learning, they're writing articles, they're publishing, they're attending seminars, they're teaching, they're really trying their best. So if it's an issue of communication, try that first. And I would say the same to any of our clients. If there's something that they're really worried about, they can always reach back out to us. We are interested in hearing what they are worried about, and we'll take those concerns seriously. If we think everything is okay, we're going to let them know that. If we think that there's something deeper we need to talk about, definitely going to want to let them know that as well. So communication really is key to having a good attorney-client relationship, being open, honest, having those conversations, and also some patience, of course, and just understanding that no attorney can really make a promise or guarantee. Um, and so sometimes we don't have all the answers, and sometimes we have an idea of how things should go, but we can't promise that result, especially because things can certainly change. And yet, as I started out with earlier, we really are seeing some great things happening too. And so on the whole, I still feel very good about especially T visa work that we're doing, because I do think that the visa has a lot more protections than different categories. And it can solve a lot of options. And I really care about the T visa program a lot. It's why I published this book, hoping that other attorneys who care will be able to get a boost. And also, hopefully, we'll get great feedback from them for maybe, future sessions and things like that as well. So, and that's that. As far as the book getting into Spanish, I get that question a lot, and I'd love to get it into Croatian as well, because that's where I'm not from Croatia originally. My parents were from there, and I was born in the United States, and I went to school in the United States. But I'd love to get it into Croatian. I think it'd be so amazing. Our first priority, however, is going to be getting it into Spanish, and we have a translator working on that. So I'm hoping by this winter, like November or December, we should have a Spanish version out. And the purpose of the Spanish version is to help Spanish-speaking attorneys to be able to communicate these ideas and thoughts better in their consultations, right? With new ideas for questions and things like that. And also, there should be a glossary as well, because I struggle with explaining things in Spanish, like deferred action, la acción diferida. It's like doesn't really mean anything in Spanish. Like acción diferida, deferred action doesn't actually mean anything in English either. But we know what deferred action means legally. It means that the government isn't pursuing a deportation. It means that a person has lawful presence in the United States, and so there's a reason that we use those terms. So the Spanish edition that we're working on, we're hoping to have a really good glossary there. And as I've been working on it, I've definitely learned more Spanish as well. I was like, I wish I'd known these vocabulary terms better, because I've been using more simple words sometimes in Spanish as I've been trying to describe things. So that's one of our current projects as well, just trying to keep people informed. So Thank you all so much for listening. I saw some really great friendly names and faces here today. Thank you so much. Have a great rest of your day, and we'll see you on our next Facebook and YouTube Live. Oh, and if this was helpful to you, please send stars. Even tiny little stars help us improve our program outreach. I always get reminded to say that by our people. Thank you. Bye.